Well, we'll let it be placed tomorrow. See if papers can be made ready.
Not an official order, my lord.
I cannot because there is another division bench order standing. So I am not within one day what can be done. I do not know. Let's see. Let it come in the list tomorrow. Then only something can be done. Otherwise, nothing.
Apply. Permitted.
The office will take steps. I do not know what is the procedure over here.
Get it scanned from Calcutta also.
Yes, yes. If scanning is permissible, then please do the scanning and get the papers.
Like.
The other side, Mr. Chakraborty will be there.
I'll also give a written notice.
Yes.
But the private petition, I'll see appeared. I'll also. Apply.
Yes. Call the list, please.
Item number 1, WP City 45 of 2024.
Yes, sir.
I am appearing for the respondents. I am raising a maintainability of the.
Why is it not maintainable?
They approved the and the original applicants before the tribunal.
Yes.
Tribunal passed an order in my favor. They challenged that order. Dismissed. Against dismissal, they did not prefer any SLP before the Supreme Court. We filed contempt application before the tribunal. Immediately thereafter, challenging that order, contempt order, they filed.
We are not seeking, I think perhaps my misunderstanding.
No, I am not misunderstanding.
Our objective is not to overreach this honorable court's order. We are seeking this honorable court has specifically observed that we should not be apprehensive that the direction of the cat is mandated. So therefore, this honorable court permitted us to pass an order in accordance with law. When we passed an order rejecting their claim, then they moved a contempt petition, and the cat says that no, there was a mandatory order. As if it was not open to us to decide their representation in accordance.
Please show me the orders.
Yes, may I just show each
The
of the
order is
orders?
not mandatory. Why they filed the appeal before the honorable?
That is exactly.
Let us see. The original order.
Yes, my first see order at page 159, which is the order passed by the Central Administrative Tribunal in the first
64, 164,
159. Right,
Yes, please.
as you see, the applicant in this OA has solved the following thing. Kindly see the important set aside include office order. Dated Ministry of Finance, Department of Expenditure dated such and such, along with office order dated such and such, and order of Government of India, Ministry of Home Affairs, whereby and whereunder the claim of the applicants have been rejected for upgradation of pay scale of malaria inspectors working under the Andaman and Nicobar administration from rupees 4,000 to 4,500 7,000 with effect from 1st January 96, along with Andaman and Nicobar administration order dated 16 December 2016. Indicating decision of Ministry of Finance along with Ministry of Home Affairs regarding rejection of the applicant's claim. We did a communication dated 28 May 2018 to all the applicants.
Very well. Then all right.
Operating for
The
the
grievance.
scheme.
The grievance, my lord, will see at page 165. And then my lord will come to the their grievance, my lord, 167, bottom of the page. They are agreed as the Andaman and Nicobar Administration Department of Health, despite fulfillment of all eligibility criteria as per eligibility rules, refused to upgrade the pay scale of malaria inspector from such and such with effect from such and such. Vis-a-vis the identically placed employees working under other union territory like Goa, Daman, Diu and NCP of Delhi, who have been granted higher pay scale. It is alleged that discrimination by violation of Article 14 and 16 were meted out to them. As such, all applicants filed the original application. Now, kindly see, my lord. The contentions of the respondents are recorded page 169, bottom of the page onwards. And then, my lord will see the findings of the tribunal. At page 174. In the aforesaid backdrop, having noted that there are no dissimilarity in the entire qualification and nature of duties and responsibilities of the applicants and the RRs of the malaria inspectors of ANN vis-a-vis the malaria inspectors of government due are not at much variance, we would be constrained to hold that malaria inspectors of ANN islands would deserve identical upgradation as they have sought for at par with the counterparts of UP of Daman and Diu. Hence, the matter be referred to the appropriate ministry for reconsideration to issue its order within 6 months. This is the order of the CAT. Now, kindly see the order of this honorable court at page 175.
This you took up in appeal.
This was challenged. Now, kindly see, my lord. Page 175. The present writ petition has been preferred by the ANN administration and its functionaries, challenging an order dated 7 June 22, passed in OA such and such. Learned advocate appearing for the petitioner submits that the learned tribunal, having arrived at findings that there is no dissimilarity in the entire qualification and nature of duties and responsibilities of the applicants, respondents hearing, and the recruitment rules of the malaria inspectors of Andaman and Nicobar vis-a-vis the malaria inspectors of Daman and Diu are not at much variance, erred in law in referring the matter to the appropriate ministry. According to, in view of the findings arrived at by the learned tribunal, nothing is left to be reconsidered by the appropriate ministry. The directions contained in the impugned order passed by the learned tribunal mutually contradictory and self-defeating. As such, the impugned order is not sustainable with law. Mr. Das, learned advocate appearing for the applicants herein submits that petitioners are entitled to similar benefits. The administration itself has recommended for upgradation. Observing inter alia, the respondents are in the same footing and the nature of duties and qualifications are same. Having recommended the claim, the administration cannot turn back and oppose the direction towards reconsideration of the matter by appropriate ministry as directed by the tribunal, more so when the order dated 1722 has not been challenged by Government of India. Having heard the learned advocates appearing for the respective parties and considered the materials of record, in the order impugned, the learned tribunal has quoted a memo issued by the Director of Health Services to the Principal Secretary Health, Andaman and Nicobar Administration, recommending the respondent's claim. Clauses 4 and 5 of the said memo runs as follows. Also, it is to inform that similar upgradation of pay scale of malaria inspectors of Daman, Diu and DNH has been done by the administration of Daman, Diu, but similar upgradation of pay scale of malaria inspectors of ANN Island has not been done so far, though they are in same footing and the nature of duties and educational qualifications are also with same with malaria inspectors of other states of India and UK. The learned tribunal has also observed that malaria inspectors of Daman and Diu were extended the upgraded pay scale of 4,000 to 7,000 by virtue of an order of Mumbai bench. In the background, learned tribunal has referred the matter to the appropriate ministry for reconsideration. Now, I will see the next paragraph. In our opinion, the argument that in view of the observations made in the impugned order, nothing is left to be reconsidered by the appropriate ministry is misconceived. The impugned order does not suffer from any patent error, any manifest injustice, voluntary interference. So, my lord, the writ petition is dismissed, and the court has specifically observed that the contention that affects to putting the cart before the horse is misconceived. After this, my lord, pursuant to the order passed by this honorable court, a speaking order is passed, which is 31st July 2024, which is at page 177. Now, my lord, 177, my lord, after recording the various legal proceedings, kindly see, my lord, 178, bottom of the page. And whereas in order to comply with directions passed by the Honorable High Court, Ministry sought detailed, and this is, my lord, will note at 177, this is a decision of the Government of India, Ministry of Home Affairs.
Rejecting the claim of
The
the.
claim is rejected by
Yes.
present order. Now, and secondly, it may also be noted that this very order has been challenged by them by filing an original application, which is pending before the CAT. Now, my lord, after this 183, my lord, is the decision of the ministry directing, my lord, the administration to prefer an appeal. That, my lord, will find at page 183.
Appeal against the division bench's order.
No. Appeal against the order passed by the CAT.
179 is the order of the ministry.
183, yes, ma'am. 179 is the order of the ministry.
This must have been challenged by the applicants.
Yes, now what they do is, After my lord, yes, this is challenged by the applicants. Then my lord will see 209 for a moment, page 209. Kindly have my lord page 209.
Yes.
This my lord is a letter uh, from the Ministry of Home Affairs directed to the administration. Uh, they have advised preferring an appeal against the order passed by the CAT. So there is no doubt as to the fact that the ministry is
1 minute. Which order?
that I am coming to. That is the impugned order. Now kindly come, my lord, to the impugned order.
Page 37 is the
Page, kindly come to page 37. That is the impugned.
contempt proceedings.
Contempt, they initiate contempt proceedings.
No, you tell me 179 is the order of the ministry.
That is, they are challenged by filing an OA.
Where is that?
That OA is pending in CAT.
That is
That is
pending.
pending. Despite the fact that they have also filed an OA, they also move a contempt. And in the contempt proceedings, my lord, we'll see at page 37. This is the order which we have challenged by this bench. Kindly see, my lord, page 37. The instant CP has been filed by the applicant petitioner being agreed with non-compliance of the order dated 7 June 22. Passed in OA. Now, my lord, the operative direction is set out. On the next page, the operative direction of the writs, the writ code is also set out. Then, my lord, will see at the bottom of page 38, it has been strenuously submitted by learned counsel for the applicant that though the respondent contenders have not preferred any appeal, however, the Undersecretary of Ministry of Home Affairs with a letter dated 31st July 24, communicating the order of Andaman and Nicobar administration rejected the claim in total violation of order of this tribunal as well as the Honorable High Court. When learned counsel for respondent alleged contender is undertaken to file Wakalatnama, he submits that they have already sent a proposal with a letter dated 31st July 24, same has been rejected. And therefore, respondent alleged contender has nothing to add to this. Heard the parties prelude material on record, admit. And MA has been filed by extension satisfying the remittances. It is to be noted that none appears to respondent contempt number 127 in the ministry. Registry is directed to issue notice to all the alleged contenders from perusal of the order passed by this tribunal as well as the Honorable High Court. And speaking order passed by the Minister of Home Affairs, we find that though there is a clear observation and direction on the part of this tribunal to extend benefits, being similarly circumstanced with the UT of Raman and Dev, however, without preferring any appeal or review of the order of the High Court, the alleged contender issued an order contrary to the letter and spirit of the order of this tribunal. Therefore, last chance is granted to comply with the order and file compliance report by the next date with this matter on 5th December. So, my lord, if this was the import of the tribunal's order, there was no requirement to send it back at all to the ministry. The mandamus can be issued by the matter has travelled up to the High Court also. So, my lord, there was definitely it was sent back for reconsideration. Those observations were made in the context of the matter before the court, which called for a consideration. So, my lord, because in satisfying the,
I get it.
so my humble submission is they have filed an original application that may be decided in accordance with law, but in the meantime, let the it is tagged also. So let the why should the content
Tagged with the content?
tagged with the content. The original application is tagged with the content. So my only humble submission is let the original application be decided. They have challenged it in accordance with law. And in the meantime, there should not be contempt proceedings while the original.
Yeah, I got it. Yes.
The order of the tribunal may be seen.
Yes.
7/6/2022 appearing at page 174.
Yes.
Clear cut direction there. In the aforesaid backdrop, having noted there is no dissimilarity in the entire qualification, nature of duties and responsibilities of the applicants, and the RR Supra of the malaria inspectors of Andaman Nicobar vis-a-vis the malaria inspector of Raman Devi are not much variance. We will be constrained to hold that the malaria area inspectors of Andaman Nicobar would be deserve identical upgradation as they are sought for, at par with the counterparts of UT of Daman and Dev. Hence, the matter is reported to the appropriate ministry for a reconsideration issue its order within 6 months. There is no direction upon them to pass any speeding order. If it is so, why they file the writ petition on next page? Kindly visualize page 175 in this. Why they file writ application? It is only for consideration. They know that.
But do you not think that the fresh OA that you filed
My lord.
and the contempt should be heard together.
My lord, I do not know whether original application was filed against the order passed by
Because
the. They say that.
what is the instruction of your client? You didn't take instruction.
My lord, I just got
Because your prayer has been rejected.
My lord,
The ministry has rejected your
ministry
prayer.
rejected, but court passed a mandatory order.
What is your remedy? You have to challenge it. You cannot take it and hold it back with you.
Correct, my lord.
Because your prayer has been rejected.
Yes, but court's order is sitting upon them, my lord.
Court's order, when said and done, is for reconsideration. Now, if it is not reconsidered in the manner as directed by the court, your contempt is pending.
My lord.
Right? And at the same time, the okay, which your learned friend is speaking of, is also pending. Let the tribunal decide both the matters and then a decision will come.
Where prayer may be seen, my lord. They are asking for passing the contempt proceedings.
No, that.
That can't be allowed.
They can pray for the moon. But the court is directing the contempt and the OA to be decided together. It has been tagged already.
Without giving any unnecessary adjournment to either of the parties.
Very.
Because we are suffering a lot.
Yes,
OA
yes.
number is OA 1356 of 24.
Thirteen 56 of 24,
Yes, sir.
right? Are you aware?
Yes, I have seen that it is mentioned in the order. This writ petition was just handed over today morning.
Okay. So impromptu preparation.
Yes, my lord. But 10 minutes gap, I got it, I prepared.
So what do we do?
Yes.
Let both the matters be decided.
My lord, within time frame, it should be disposed of. My lord, pending since long.
The Supreme Court is deprecating this practice of fixing a time limit to decide matters.
Yes, without giving unnecessary adjournment. That will serve the purpose.
That will be done. Show me the order, the impugned order over here.
Impugned order, my lord,
37.
37. Contempt is 37.
My lords have updated, it is OA 1420 of 24. Just now it's 1420 of 24.
Where is the number?
OA 1420.
Where do I get the
No, it
number?
was not tagged then. This is original application, 2018.
No, 1420.
Yes,
Yes.
page 37 may be seen.
No, that is fine. I am not.
You made submission that it was tagged
That's
together.
my separate order. I have been instructed it has been tagged. Neither has it been. How it will be tagged? How does?
No, you
It is the correct number.
I have got it just now, my lord. It is OA 1420 of 24.
Not 1356.
1420 of 24, and it is. This is mentioned in the read also. I just show from the read itself.
Page 37 on OA is mentioned, that is the original OA.
Yes, I just
2018.
That is the 18 matter.
Yes, that is.
No, after the order was passed by the ministry, the fresh OA which has been
I
filed.
will just show that. Kindly have. Kindly have, my lord, page 29 of the writ petition. In fact, 28, bottom of the page. Roman 7. Incidentally, the respondents had accepted the speaking order issued by the and challenged the same before the learned tribunal, vide OA 351/1420/2024, which is likely to be listed before the Honorable CAT on 5th December 2020. This is the OA now.
This is the number.
The parent order is 159. High Court order is 175.
Please come.
And my lord, it is confirmed that it has been tagged. My learned colleague has just pointed out by an order dated 30th September 2024. It has been tagged.
And the content number, page 37.
Yes, madam.
It's
Contempt petition number 9 of 2023.
9 of 2023. Yes.
And OA number is 1420 of 2020.
The Union of India and others have preferred the instant appeal, instant writ petition, challenging the order passed by the Learned Central Administrative Tribunal, Kolkata, on 27th of September 2024 in CP 9/2023 within bracket Port Blair, arising out of OA number 1133/2018. Stop. The contempt application was filed by the original applicants,
madam.
alleging non-compliance of the order dated 7th June 2022, passed in OA number 1133/2018/AN. Stop. Paragraph. The applicants have challenged the order passed by the ministry, allegedly in compliance of the direction passed by the tribunal on 7th June 2022 and rejected the prayer of the applicants. Stop.
May submit one thing. The High Court also dismissed, that may be recorded. 175.
The what did I say? The last line, what did I say? Yes. According to the petitioners, the ministry acted in accordance with the order passed by the tribunal in directing the ministry to reconsider the case of the applicants. Stop. Next. The original applicants contend that as the tribunal directed the ministry, the manner in which the prayer of the petitioners, the prayer of the applicants was required to be considered, the ministry could not have considered the matter in a different way. Stop. This is the reason as to why a fresh writ petition has also been filed, not writ petition, original application has been filed before the tribunal challenging the order dated 31st July 2024, passed by the ministry, rejecting the prayer of the original applicants. Stop. Paragraph. Learned counsel representing the original applicants submit that as the order passed by the tribunal on 7th June 2022 stood confirmed by the Honorable Division Bench on 20th July 2023. Accordingly, the prayer of the original applicants ought to have been allowed, and there is hardly any scope to reject their prayer. Stop paragraph. The parties have assailed the order, and not the parties, the petitioners have assailed the order passed by the tribunal in contempt by submitting that as the original application filed by the original applicants is original applicants challenging the fresh order of rejection dated 31st July 2024 is pending consideration in A number 351/1420/2024. Accordingly, the 2024 and the original application has been tagged with the contempt application. Accordingly, the learned tribunal in the contempt proceeding ought not to have directed the ministry to comply the same prior to deciding the order of rejection on merits. Paragraph. We have heard the submissions made on behalf of both the parties. Stop. The court has been made aware of the fact that the original application has been tagged with the contempt application. Stop. If at this stage the contempt application is allowed by directing the ministry to comply the order passed by the tribunal on 7th June 2022, then the subsequent original application being 351/1420/2024 will be rendered infructuous. Stop. As the validity of the order passed by the ministry is already under challenge, it will be better if the contempt application and the original application both are taken up for consideration by the tribunal simultaneously and adjudicated and disposed of. Stop paragraph. The learned tribunal paragraph is accordingly requested to consider the original application being A 351/1420/2024 and the contempt petition being CP 9/2023 analogously and dispose of the same at the earliest without granting any unnecessary adjournments to either of the parties. The writ petition stands disposed of.
Blair.
Anything else?
Contempt is pending, not the matter.
Yes.
5 is the date for
Yes.
for submission of.
Item number 2, WPCP 46 of 2024.
I am appearing for the respondents, maybe. Already settled matter by this honorable division bench.
We have to include order, page 15.
Page 15,
Correct.
1-5. Yes.
Hmm.
And on see at page 16, the applicant retired from the services of care and administration on 31st December 2012.
Yes.
In 2015, he obtained treatment for dental disorder from GB Park Hospital, which referred the applicant for further treatment to a hospital in the mainland. He was treated in a private hospital in Chennai, where he incurred an expenditure of 6 lakhs. He applied for reimbursement of his expense to his former employers, who, in compliance with the direction of the tribunal, owed such and such issue speaking order advising the applicant to approach his last office, that is, Directorate of Shipping Services, which had earlier rejected his claim on the ground that having retired from service, applicant is not entitled to medical reimbursement from the government. Learned counsel for the applicant submits that the issue of eligibility of retired employees for reimbursement of medical expenses have been decided by this tribunal in OA such and such, whereby it is held that retired employees are entitled to medical reimbursement at par with the serving employees. Learned counsel for the respondent calculated the stat of the respondents and medical reimbursement to retired employee of administration is not provided for in any under any scheme or policy. Therefore, the claim of the applicant to the retired.
Where is the service rules?
We are saying there is no, it is not provided for under the rules.
Show me the rules.
But,
At least 3-4 judgments are there, my lord, of our.
Show me the rules.
the page, I not will see the memorandum, which in fact, page, a large number of memorandums are there. My not will first see page 62. You see page 62.
Yes.
This is the first memorandum. The undersigned is directed to state that various references have been received in the Ministry of Health and Family Welfare on the above subject, which is reimbursement of medical claims to pensioners. This hereby under the CSMA rules 1944, as directed by various CATs courts. I would kindly see the undersigned is directed to state that various references have been received on the above mentioned subject, which is hereby clarified that CSMA rules 1944 are not applicable to pensioners till date. It is further informed that following options to avail medical facilities are available to central government pensioners. A. Pensioners residing in CGHS, we are Andaman Nicobar Islands is not a CGHS area, therefore D will apply. Pensioners residing in non-CGHS areas, they can avail fixed medical allowance. 2, they can also avail of CGHS, OPD and IPD by registering themselves in nearest CGHS city after making the required subscription. 3, they also have the option to avail FMA for OPD treatment, that is fixed medical allowance for OPD treatment, and CGHS for IPD treatments after making required subscriptions as per CGHS guidelines. In view of the above, reimbursement of medical claims to pensioners under CSMA rules as directed by various CATs, courts need not be referred to Ministry of Health and Family Welfare. Respective departments may take their own decision in this regard. Further, all departments are requested to intimate their employees proceeding for retirement regarding the above option. So either they take fixed medical allowance or they register themselves with CGHS facility. Now, or they register themselves CGHS in the nearest city, which has CGHS facility. Now, in this case, actually, this gentleman had applied for FM, fixed medical allowance. Now, kindly see, my lord, the next office memorandum, which is this is again, this is applicable, my lord, to those who are under the CGHS scheme. So this gentleman was not under the CGHS scheme. This memorandum is as such not relevant. Now, kindly see, my lord, page 68, which is a memorandum dated 19 December 1997. Implementation of government's decision on recommendation of the 5th Pay Commission, grant of fixed medical allowance of 100 per month. This was earlier 100 per month, and my lord will see that this was revised subsequently. And at page 62, my lord has noticed
500 rupees.
500 rupees is mentioned.
And still now that is in vogue?
Now it is 1,000 rupees, my lord.
Where is that?
That my lord will find. First, my lord, 2017. 2017, my lord will see page 70. This is grant of fixed medical allowance for central government pensioners not residing in areas covered under CPHS. And my lord will see that this is initially extended. First paragraph records that it was enhanced from 300 to 500. The second paragraph, kindly see second paragraph. Consequent upon the decision taken by government on recommendation of the 7th Pay Commission on allowances with modification, sanction of the President is hereby conveyed for enhancement of amount of fixed medical allowance from 500 to 1,000 crore. So, my lord, this is increased, my lord, from 500 to 1,000 per month. Now, his representation of 2016, my lord, to the Directorate of Health Stripping Services at page 72. And what will then see.
So this is the last revision, page 70, 2017.
Yes.
There must be something relying upon which the CAT is passing orders for grant of reimbursement.
There are some orders, my lord, I have to.
It is there in the impugned order itself, my lord. Honorable High Court decided already.
Coming to that, my lord, I finally have page 89.
Show me the impugned order.
Yes, impugned order, my lord, and we, my lord, comes back to page 16. Paragraph 5. Paragraph 4, heard the parties pending the material on record.
Judgment of the tribunal in such and such 2021 affirmed by such and such not to reject the claim. Yes, but then there must be some material on which the order has been passed.
Now, my lord will see the one of the orders of the tribunal, which my lord will see at page.
This is the judgment, my lord. I am.
82.
Page 5, the judgment of the tribunal affirmed by the honorable bench is mentioned. Where is
the High Court?
Oh,
Already settled long back, my lord. I am 74 years old now. For the last 10 years, I am running pillar to post. High Court. Yeah, Leonard Friend only appeared. Not only that.
He is not a retired person can get such type of including.
This is the judgment of 2017 by
WPCT 44, Rajkumar Shaw. Which portion would you like us to see?
my lord. Page 3, my lord.
Yes.
Paragraph 2. The tribunal, after taking note of the division bench judgment rendered in V.A. Abraham, allowed the tribunal application directing the reimbursement of the medical expenses submitted by the respondent within specified time. Though the Council for the Union of India is very much critical on the observation recorded by the tribunal that the direction in this regard cannot be passed, the moment CGHS facility has not been extended to the petitioner, nor the same is admissible under CSMA rules, but we do not find that the aforesaid stand can be sustained in view of the fact at all. Such plea were taken in the plethora of cases initiated by the several retired employees of the administration, and uniform decision as was taken to extend the facility of medical reimbursement. Right to life inbuilt within the itself a right of healthy life. It is duty of the government or administrator to protect the health or vigor of the employee and also to provide medical facilities, not only during the service but thereafter. It is fundamental human right to live with life in meaningful and purposeful manner with dignity. It is equally important to provide all
Yes,
things.
I read it.
Yes. This is the first judgment, Milan. Prior to that, wrong that Justice Indira Banerjee and Justice Aluwalia Milan passed the order.
V.A. Abraham.
V.A. Abraham, they preferred appeal Milan up to Supreme Court. It was dismissed. And this is recent judgment, Milan, by Honorable Justice Ajay Kumar Mukherjee, Milan, imposing 6% interest also. Already settled matter, my lord. I am 74 years, my lord. Now, how many years I am going to live, I don't know. For the last 10 years, I am running pillar to post. It is not a simple case of medical treatment, my lord. The dental department of GBP hospital referred my case to mainland for treatment. No such facilities available in this.
Are you registered with the CGHS?
My lord, it is not applicable, Andaman.
It's not.
Not applicable.
No, the portion, the B portion that was read out.
Even then, my lord, for referral case, that is not applicable. Because no such treatment is available in Port Blair.
Oh,
I was referred to mainland for treatment. That referral portion, my lord, well, I'm very sorry to say that it is not enclosed with the writ application.
petitioners residing in non-CGHS
where is the
fixed
provision?
medical allowance.
Where is the provision that in
They can
referral
also.
case, this office memorandum will not be applicable?
Well, whatever amount will come to the referral case, because no such facilities available in Port
Is
Blair.
there any provision in this regard?
Based on the judgment of this court, my lord.
It has to be read into it. If the island cannot provide the facility and the person is referred to the mainland, then obviously reimbursement should be there. Why not?
The Indian bench order which has been showed.
Which one? Which one?
Same fact.
Rajkumar Shaw.
Rajkumar Shaw.
These are all the decision terms of the facts. The facts of this case, my lord, our contention is that the petition applicant had actually had chosen to avail of the fixed medical allowance. Now, my lord will see this office memorandum has not been considered in the Indian bench's order.
Maybe.
Page 62, kindly have for a moment. So far as pensioners residing in non-CGHS areas are concerned, they have options. It is not like they do not have an option. They are aware of this memorandum. They either choose to, they can avail of fixed medical under one. Number two, they can register themselves with CGHS facility in nearest CGHS city, which is Chennai, if I am not mistaken. And my lord, in any event, my lord is aware that my lord in Andamans, my lord, when usually my lord, if there is any serious illness, either Chennai or Kolkata, my lord. So my lord, they are used to going for treatment to the mainland. It is not as if people do not avail of treatment in the mainland. So why not? He had an option of availing of the CGHS facility in Chennai. And third point is they can go for both. For OPD, they can go for fixed medical allowance because my lord, otherwise it is free. The government hospital here, my lord, provides free facility. So my lord, fixed medical allowance for OPD treatment and for IPD treatment, you can go for CGHS. So the employee had an option of registering for CGHS in the nearest city, which is Chennai or Kolkata, for the purpose of IPD treatment. For OPD, he could continue to take this fixed medical allowance.
In this case, whether it's OPD or IPD.
Yes,
It was a referral, my lord.
now kindly see the order
On referral, IPD on referral.
Yes.
Referral case, that fixed allowance is not applicable.
Kindly see the order which is passed, page 95, which was challenged in the CAT and which my lord the CAT appears not to have considered. Kindly see page 95.
Yes.
This is the order dated 10 February 2021, whereas an application was filed by one Sri Mohammad Ali, retired assistant director DSS before the honorable tribunal, which was disposed of on 30th December 2022. Applicant inter alia prayed the following relief before the honorable tribunal, set and quash letter dated such and such, pass an order by directing responsible authorities to release the amount of 6,13,000 incurred by applicant at Chennai medical treatment dental to pass such other order or orders or directions. Now kindly see tribunal while disposing of the said application pass the following relief. Operative part O is disposed of with direction to appropriate authority who accepts the documents in support of medical reimbursement claim to be submitted by applicant and take a decision in accordance with the rules. The applicant should submit the relevant documents within a period of 2 weeks. Now kindly see the applicant in terms of the said solemn order submitted representation claiming for reimbursement within the said period. Whereas the perusal of the document submitted along with the original applicant, the following facts emerged. That the instant applicant retired from the post during the year 31st December 2012. Applicant had some medical issues that had approached the GB Funds Hospital, Port Blair for treatment. It is understood that for better advanced treatment, applicant preferred to get his treatment done at hospital in mainland. Applicant preferred to get his treatment done at a hospital in mainland. Applicant stated that he got his treatment with regard to his dental issues and aesthetic Smile Dental Clinic Chennai, where applicant is alleged to have incurred an expenditure of 6,13,000. Subsequently, applicant submitted a claim for reimbursement before the Directorate of Health Services and the first instance. Director of Health Services had rejected the claim on 6 September 2017, further stating that hospital expenses are not admissible under ANI SHI scheme. That the applicant not being satisfied approached the Honorable Tribunal, which disposed of at the stage of admission with direction to pass necessary order. Directorate, however, was not made a party. That the DHS administration, however, rejected claim of the applicant with the order dated 30th August 2018, further directed to approach the Directorate since he retired from the DSS. Applicant made representation to the Directorate for reimbursement, that is the Director of Shipping Services for reimbursement, which was subsequently rejected by Directorate by stating that the claim is not admissible under CSMA rules to retired government service. Instead, OAS directed against the order pertinently mentioned that tribunal, while passing the judgment and order, have directed take a decision. There is strictly in accordance with the CSMA rules, which reads as follows: this shall apply, my lord, to all government servants other than one, those in railway service and those of a non-gazetted rank, stationed in or passing through conditions of service are prescribed by rules. When they are on duty, leave or for such and such pension in railway service excluded from purview of these rules. Railway employees are deputed. These rules do not apply to one, defense service personnel; two, government servants who are on leave or deputation; three, non-gazetted servants, including Group D and gazetted government servants drawing pay less than 2,500; retired government officials. And the Government of India has issued circular wherein the claim of medical reimbursement of pensioners under CSMA rules are not applicable. Further, the applicant, who is a retired government servant, is already availing fixed medical allowance of 1,000 per month on superannuation. That the instant applicant is not entitled to claim medical reimbursement as per CSMA rules and as per the policy decision of the Government of India, retired government servants are not entitled for any medical reimbursement. So now, my lord, this page 62, that this order has been passed in terms of the Government of India's notification, which is at page 62. Now, this notification has to be struck down in that case. My lord, if this notification is because this is applicable throughout the country. Now, my lord, without striking down this notification, my lord, on what basis, my lord, when he has elected for the fixed medical allowance, on what basis, my lord, the benefit he chose in this case that he for this is a dental treatment to avail of better facilities, he chose to undergo the treatment in the
Is there any document to show that he was referred?
Referred, my lord, that
Where is
document
that?
He's saying
not
that
filed before the court.
You have it with you?
Yes, it is there. Page 84 may be seen. Certificate given by HOD. 84 of 83. Referral letter with
certified that such agent 65 where whose signature has been advised by dental department of CB Punch to undertake further treatment to any dental clinic in the mainland immediately due to past discharge and he was unable to chew and eat food. Accordingly, such and such undertaken complete premium aesthetic Smile Dental, Dr. Satish such and such has issued bills as section A and B under his signature separately as reported to this dental department of return has been physically examined with reference to claim for reimbursement found to be genuine and recommended. So this is a certificate.
It is certificate. Referral letter. Why you not included?
Represent.
It is there. This should be. It should be dismissed with exemplary cause for suppression of material.
No, where is
document.
Did you submit this before the authority?
Yeah, no, it is part of the original application.
It is the part?
Yes. Page 83 may 82 may be seen, Melo. This is page 83. They should file it. Purposely it was not filed. Yes, I will say that. Purposely it was not filed. I will show my original application also.
Yes, page 82 is there.
82. The referral letter is 83.
This has not been issued.
Yes. Not filed, Melo. I will show from my original application.
Page 82. Possibly the one that has been handed over is the
one page is there.
Continue.
Page appears to be missing. Yes.
Missing. It is
No,
missing. Now you say missing.
It has no.
48 and then comes 50. After page 48, it's 50. Page 82 and 83. This is the
original.
this is the return. He also admits it. It's second page.
There, why would I do it on purpose? I don't understand.
Multiple such and such.
The case of referral. Last line may be seen, my lord. mainland, referred to mainland for
For
better
the
treatment.
treatment to be
He
done,
cannot eat for nearly 3-4 months.
mainland, yes.
My lord, for the last 10 years, my lord, the litigation, my lord.
Let me understand. So page 82, there is, you avail the benefit of the GB Pant Hospital
My lord.
where you are entitled to in term, free treatment.
Hospital is free.
So anybody can go
Yes,
to
it
the
is a
hospital
walk.
and get
It is
services from there. And then
thereafter, no facility available.
why will this free treatment not be reimbursed?
No, but I don't.
Free treatment, I am not claiming.
I get it.
I thought GB Pant may be a government hospital, but GB Pant is not the employer, my lord. So, my lord, barely because the government hospital has referred doesn't make it obligatory upon the employer to bear the expenses under CGHS scheme, where the employee has elected to only get the fixed medical allowance. CGH, the facility of GB Pant is free for everybody living on the islands. But my lord, the point here is different. The point here is that whether somebody availing of medical facility in the mainland is entitled to reimbursement of the whole, the amount, the reimbursement happens under a scheme, that is the CGHS scheme. And if it is a CGHS area, the employee has the option of applying under the scheme. It is not automatic. And for a non-CGHS area, the employee has the option of applying for the CGHS scheme in the nearest CGHS registered city. Which option was available? It's not an uneducated person, assistant director of the DSS. He had the option, my lord, of applying under the CGHS scheme at Chennai. He chose not to do that. He chose to take the fixed medical allowance. So therefore, the question is, maybe this circular is bad. Then the court will strike down the circular and say that this is invalid. But how can this circular, which has stood the test of time, be simply ignored? That is the whole question, my lord.
But that was clarified by the Honorable Division Bench in the Rajkumar's office. Page 3.
Rajkumar Shaw has taken note of Article 21. And then the whole judgment is there.
Fine. They accepted this, my lord.
They have accepted this.
No, they preferred appeal also. In the earlier one,
Supreme Court.
Supreme Court dismissed that.
In the Rajkumar Shaw's matter.
No,
There is no
Abraham matter. This is based on the Abraham's judgment. My lord, you will find page 3, second paragraph. In the tribunal, after taking note of the division bench judgment rendered in V. Abraham. In the Abraham matter, the administration preferred SLP. SLP was dismissed. So reimbursement was
Where is
allowed.
the consideration of the office memorandum at page 62? Kindly see the finding at page 4. Page 4 says.
In 1 minute, in Abraham, where is the discussion by the court with regard to this office memorandum? Reimbursement.
No, I don't have Abraham. My lord, it is there in the page 3, it is there, my lord, Rajkumar Shah.
Abraham judgment you just handed me.
No, Rajkumar
Justice Rajkumar Shaw and then Justice Indra Banerjee and Justice Ahluwalia's judgment.
Yes, ma'am. Yes. Oh, my lord, possibly page 2, para A.
Yes, page 2.
In fact, this judgment predates the circular at page.
Maybe.
So, which was under consideration.
No, but then the fixed medical allowance and everything is there.
Yeah.
हम करके देखेंगे. They preferred appeal also, my lord, appeal was also dismissed. My lord, I got the Supreme Court order also.
Yes, please give.
Single page order. Sorry, my lord.
1 page, that means no discussion is there.
I am very
SLP has been dismissed.
only one page is there.
Special petitioner is dismissed. Union of India versus PA Abraham.
I worked for the department for
delay.
35 years, my lord.
Yes.
Not only.
But there is nothing on merits. It's only on the ground of delay that it has been dismissed.
In 1,000 rupees, my lord, nothing will happen. Lordship knows that. If we go to Apollo Hospital for one X-ray, they will charge 2,000.
I just wanted to know whether your service rule provides something about this. Your service rule is against you. Right.
My lord. Medical rules, my lord, that is not applicable to Andaman Nicobar Islands. Is there?
No, whatever is there, something must be there for you.
Must be there.
There must be something.
Is free, my lord, in GP Pant Hospital. If in case of referral, the government used to give the entire amount.
Treatment in GB Pant hospital is free for all,
Everybody.
not for this purpose.
No, it's for all.
So,
In the time of referral, my lord, they used to reimbursement.
Where is that law? Where is that
Based on
office
the
memorandum or something?
Judgment only, my lord, they're claiming. Approach the tribunal passed the order saying that Rajkumar Shah is there, therefore I am entitled. They challenge that. For the last 10 years, well, I am litigating, well, kindly appreciate this. Now I am 74 years.
I understand, but then there has to be a substance. What did Justice Mukherjee hold?
Discussion.
Justice Mukherjee, my lord, elaborate judgment was passed.
Which portion do we see?
My lord, I don't have the copy, only 2 copies have handed over. I know.
He'll get it in the phone just now. Give the case number and the date, he'll get it.
It's there.
24th June 2024.
Even my lord, interest was also awarded by Justice Mukherjee. Honorable Justice.
Rajkumar Shah, WBCT. You were there, Mr. Chakraborty was there, I see.
Yes, my lord. My learned friend only appeared.
so your claim rests only on the decision of
Yes.
Yes.
and no other statutory
No.
ground for your claim.
My lord, court made law is always applicable. वही तो भैया। इसमें है मतलब date of the judgment.
Date of the judgment is 24th of June 2024, WPA 756 of 2023. Shri P. Krishna Rao versus PBMC. Mr. Chakraborty, in case you want to go through this judgment, you please come back. Yes, so then the discussions, what all you are submitting today, everything is recorded. So there is no requirement of hearing you all over again on the same issue. It has been conclusively decided. Any appeal preferred against this?
No.
Not yet. No, even if it is now done, it will be a time-bound appeal, then something else. So this is the law as it stands today. Maybe, but it doesn't matter, but then it has been elaborately.
The other issue is that my lord, one other thing, my lord, instructions, told that my lord, several of the documents submitted are undated, etc. So, my lord.
Which document?
Submitted for reimbursement.
All right.
So, my lord.
That is something else.
This is something else. So, my lord, that according to me, even the CAT has said that my lord will see the operative direction.
Yes.
Page 17, we therefore direct the respondents to consider claim for reimbursement of medical expenses incurred by applicant and without the influence of their earlier decision rejecting. So, my lord, if the claim is found in order to make payment, so my lord, that part, my lord, should not, my lord, my humble submission is, my lord, obviously, if it is otherwise, it's not found.
No, already I submitted my claim.
Eligibility the courts have held. So that way you cannot deny him. But the documents you want to verify is something else.
That much. This cannot be understood to mean that it has to be given to him if the documents are not.
No, document already I submitted long back.
No, it may not, because my lord.
Now you cannot say that I have not submitted any document.
Eligible documents have not been verified. Because he has been fighting all this while on the issue of eligibility itself.
Yes.
If it is held that he is eligible, even then the documents will have to be verified. That my lord, that much my lord.
So we record that.
Yes.
My lord, I got a letter from the department. This is my reply to that.
Did they seek for any other document?
So they asked me, my lord, I clarified that.
So that my lord is a fact finding exercise that the
Yes.
do.
This is your letter that you are giving in 2019. The medical reimbursement submitted by me are still lying in your office.
Yes, already I
Representation there. Let them verify it.
Verify. Verify.
Then we dispose it of here and now. Please come.
Why not the larger, the detailed question, why of course the learned single judge has looked at it.
Yes. I was just hunting whether something is there, but I see Justice Mukherjee has dealt with it in details.
Elaborate.
And there are several judgments also considered. Page 3.
And if your lordship's approval, my lord, then
Yes.
have far consequences.
You have not challenged this order. So what?
Your lordship is for how?
But then, at the same time, the employer should look into it. When a person is in service, he is of young age. He can manage. You are reimbursing the bills. And when the person is of 70,
74. No.
he is 74, but then after retirement at advanced age, why will you not reimburse the bills? There is violation. Article 14 has been looked into, right to life, 21 is there. Then I think the authority should look into it. This requires a revision rather. Please come. The order passed by the learned tribunal on 5th July 2024. In setting aside the order passed by the authority, rejecting the prayer of the applicant for reimbursement of medical expenses is impugned in the instant writ petition. Stop paragraph. The applicant is a pensioner. He incurred certain expenses on account of his medical treatment and raised bills for reimbursement. Stop. On refusal to reimburse the same, the applicant filed original application before the tribunal, which has been allowed by directing the authority to consider the claim for reimbursement of medical expenses incurred by the applicant in the light of the decision of the tribunal in OA 351/1/2021/AN, affirmed by the High Court in WPCT 44/23. Stop. According to the petitioners, the applicant will not be entitled to the reimbursement of the medical bills. Stop. The office memorandum dated 29 September 2016 by the Ministry of Health and Family Welfare, Government of India has been relied upon to reject the claim of the petitioner, claim of the applicant. Stop. It has been submitted that there is no provision for reimbursement of medical bills in respect of a retired, in respect of a pensioner. Stop. Paragraph. Learned advocate representing the applicant submits that the issue in question is no longer res integra and has been decided by various pronouncement of this court. Stop. The order passed by the Honorable Court on 29 September 2023 in WPCT 44/2023, within bracket, the Union of India and another versus Sri Rajkumar Shaw, SAW, has been placed before this court. Stop. The Honorable Division Bench in Rajkumar Shaw referred to the order passed by the Honorable Supreme Court in the matter of Shivkant Shah versus Union of India, within bracket writ petition, within bracket civil number 694 of 2015, dated 13th April 2018. How did I start the sentence? Yes, took note that the right to medical claim cannot be denied merely on technical grounds. The authorities are bound to ensure that the claimant has actually taken treatment, and a decision has to be taken by showing the human approach. Stop. The division bench also took note of the order passed by the Honorable Division Bench of Punjab and Haryana High Court in several writ petitions, holding that the action of the Union of India in not reimbursing the medical bills, as the employees are neither covered under the CGH scheme or CS within bracket MA rules is illegal, arbitrary, capricious, discriminatory, and violative of Articles 14, 16, and 21 of the Constitution of India. Paragraph. The learned advocate for the original applicant also relies upon the judgment delivered by an honorable single judge of this court in a court on 24th June 2024 in WPA 756 of 2023 within bracket Shri P. Krishna Rao versus the Port Blair Municipal Council and others, wherein the court elaborately looked into the issue and held that the decision of the administration rejecting the prayer of the employee for reimbursement of medical bills as he received fixed medical allowance on the ground that he has not enrolled himself under the health scheme calls for interference. Stop. The court was pleased to direct the authority to reimburse the medical bills of the employee. Interest on the total payment which accrued to the employee. Stop. Next. Upon hearing the parties and upon perusal of the materials on record, it appears that yes.
That also may record, otherwise, now they will go to Supreme Court.
All right, take down one more. The Honorable Division Bench, by a judgment dated 12th December 2012, in WPCT number 213 of 2007, within bracket Union of India and others, versus V.A. Abraham.
This they prefer SLP also.
Had allowed the reimbursement of medical bills in case of the employee. Stop. An appeal preferred against the order, not order, judgment dated, judgment in the matter of V.A. Abraham was carried an appeal by the Union of India and others, and with the order dated 5th April 2014 passed in petition for special leave to appeal within bracket civil CC 6805/2014 stood dismissed. Paragraph. Upon hearing the submission made on behalf of the parties and on perusal of the materials on record, it appears that the petitioner and the employee originally approached the GB Pant Hospital for obtaining medical treatment, but as the same was not available, accordingly, he was referred for further treatment in the mainland. Stop. Relying upon such a reference, the employee had to take the medical treatment in Chennai, and upon returning to the island, place the bill for reimbursement before the authority. Stop. The a certificate issued by the hospital by the HOD of the dental department ANIIMS, Port Blair, dated 7th November 2016 is already on record. Stop. Next. The court is of the opinion that as the issue as to whether such type of employee, retired employee, will be entitled to medical reimbursement has already been conclusively decided by the court. Accordingly, there is no reason as to why a different stand is required to be taken in the case of the original applicant in the instant case. Stop. It is held that the original employee will be entitled to reimbursement. Sweet. The bills of the original employee are already placed before the authority. Stop. The authority shall verify the same and reimburse the bills at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop.
Can it be subject to the verification?
Yes.
The as the original applicant is reported to be of very advanced age, and he has been moving from pillar to post to get the reimbursement done. Accordingly, the bills are to be reimbursed along with interest at the rate of 6% on the total amount that will be payable to the employee. Stop. Next. In the event payment is not made within the time limit as specified herein above, the employee would be entitled to additional interest of 2%. That is 6% plus 2% is equal to 8% on and from the date of submission of the bill till the date of actual payment. Stop.
I got my submission.
1 minute. Prior to concluding the judgment, the court is of the opinion that the authority, that it is high time for the authority to look into the issue of reimbursement of medical bills in respect of the retired employees. Stop. The reason for such review by the department is more because of the observations of the court recorded in the judgment of Rajkumar Shaw within bracket Supra. Stop. The authority to take note of the fact that after retirement, the medical expenses of the pensioners are usually on the higher side. And if the employee was entitled to receive the reimbursement while in service, accordingly, for the protection of their health, the authority should take into consideration for extending similar facility to the pensioners. Stop. The court has already held that right to life means a right to a healthy life. Stop. The issue of discrimination between the employees who are availing the benefit of CGHS and the CS within bracket MA rules is also required to be looked into. Yes.
My only suggestion is the direction of interest and also said that this has to be done within a time frame. But my lord may only say subject to verification, my lord. So otherwise, my lord, they will say that there is no
ground for objection.
No,
I mean, the moment this is added, you will go on striking off. This will be applicable to you. This will be not, and all these things.
See from the other angle also, my lord, if his papers are not in order, then also
You will
because
not
of the
submit
court
the
direction,
listing
my
before
lord.
the tribunal because
You can intimate the employee, these are the papers which are not in order. The papers are not made by him. It was made by the hospital, the authority which delivered the treatment to the employee, right? So you can take it up that way. In other cases, it will be held in a different manner. Here, this was never the issue, so it cannot be done. It's disposed of. You take these two back.
No, my lord, difficulties, my lord, there is, I'm told that date etc. is not there in the application. So that is why my lord, if my lord says that. Of my lord, he may be given.
In case any clarification is required, the authority may seek the necessary clarification from the employee, which the employee will be obliged to provide to the authority.
Right.
Call 3, and this will be the last matter in the division bench.
item number 3, WPCT 47 of 924. For the tribunal, central administrative tribunal, at the first instance protected my interest. Subsequently, on an application being taken up for vacation of the interim order, the order is came to be passed, which are challenged the proceeding application.
The private respondent also.
Yeah, this service will be made.
Is anybody appearing? Where is the affidavit of service?
I'll bring it on record. Oh, let it come to
Yes, in that case, not today. But have you checked that? Has it been served?
I'm told not by my amendments. So.
Shall I keep it? We keep it tomorrow.
Some interim protection taking place based on the interim order, the selection portion which has been stored.
All right. Then only not today.
Yes, no.
You all want a break?
No, no, I don't. Break for the whole day.
Not for the whole day. The prayer is rejected. I'll be here immediately.
Any mentioning not in the list? Any mentioning in the list? Item number one, application of 2024.
Yes. Where is the petitioner? Not here? Ashkana.
Number one is the Vijay Kumar sir is appearing, yes, mainland for his medical treatment. After that, it may be come up on next week, my lord.
Next week or next circuit?
Next week, my lord, he may be written by Friday.
All right. On the prayer of the learned, on the prayer made on behalf of the learned advocate representing the petitioner, list the matter next week.
Start so quickly, also it not get a chance to mention a matter. No, once we, this matter needs to be in this tomorrow.
Tomorrow itself? Right.
During the last circuit, I have sort of a protection that was granted. It will be expiring tomorrow.
So you want extension of interim order? Serve notice?
It's already a
Tomorrow.
One more matter where I think this is all okay. It was new principal bench of VC. Some rating protection has been granted to my client in the different institution. And the interim order would be operating till the end of this cycle. To file it from Calcutta, it may take time or should be started. It will be distant tomorrow.
Tomorrow. It has to come from Calcutta, you said.
Or Monday.
Next week?
Monday.
Extension of interim order?
No, it's already there. It's there till last.
End of the circuit, it's already,
Yes, yes.
there is some urgency because of the.
For hearing.
Yes.
You want the matter to be heard?
Yes.
All right. Next Monday, you put it in the list. Kagoj gulo.
Item number two, WPS 652 of 2024. Item two.
Only not today. Where is Mr. Vinu Kumar? Not today. Record an order on the prayer made on behalf of the learned advocate for the petitioner. The matter stands adjourned for the day.
Number three, WPS 653 of 2024. Service has been affected, already it's been sent. But I don't know what the subject is. I give instruction.
When do I keep it?
Since it's
All right. On the prayer made on behalf of the learned advocate representing the respondent authorities. List the matter next week.
Number four, WPS 654 of 2024. Same position.
Same. Can it be taken up now? When do I keep it? Very well. On the prayer made on behalf of the learned advocate representing the respondents. List day after tomorrow.
Number five, WPS 655 of 2024.
None appears on behalf of the petitioner at the time of call. List the matter next Monday.
Item number six, WPS 656 of 2024. My lord, service is not a participation from our.
By one day, will you be able to serve?
Yes, yeah.
Who has not been served?
Science and technology.
That's the point of the code.
Learned advocate for the petitioner submits that service is not complete. Stop. List tomorrow as prayed for.
Item number seven, WPS 657 of 2024.
Items of 7 and 8. Vijay Kumar. Vijay Kumar, yes. Item of inspection. Next circuit.
Next circuit. On the prayer made on behalf of the learned advocate representing the petitioner, list the matter in the next circuit. 8 also same order. You record your appearance, please. Yes.
Item number 9, WK 93 of 594.
Not today. Very well. Record an order. Not today.
Item number 10,
Same order.
item number 11, WK 305
Has it been made ready, served?
That means it made ready, they have sent it. I can verify whether they have filed or not. I can verify.
Then serve copy at least.
I can also submit.
When shall it be posted?
But if they have, get it to our next week, not, I can tell.
Let me see the file once. August, it was extended. Yes.
It is there, my lord. I apologize. It is there. Copy will serve.
1 to 3 opposition is already there.
Copy is not been.
I will make-
Serve.
Let it be on Thursday. I will find it.
The affidavit in opposition is already on record. Stop learned advocate for the petitioners. Now, let copy of the same be served on the learned advocate representing the petitioners. Stop. It will be open for the petitioners to file reply within
2 days. Let it be on Thursday for me.
4th, list on 5th.
Next one, WPA 320 of 124.
And the very for this phone number 1, 2, and 3, I will seeking a week's time to file appointment.
And for the petition. On Monday, you also very short time is involved. Opportunity of hearing has not been given to us before passing the order. That is the main point. And if that is looked into, your lordship can find out that they have made certain assessment. But without giving the opportunity of hearing to us relating to assessment, how they
A
will
week's
pass
time,
final order?
One week time. All right.
Yeah.
On the prayer made on behalf of the prayer made by the learned advocate representing the respondents. The matter stands adjourned till 9th for filing the affidavit in opposition.
Right.
List on 9th.
The father of things for the respondent, we are aware of the petition. Item number 13, WPA 340 of 592, and for the petition.
Only? Why? Ready means ready for hearing?
Yes. All the clients.
Why is it appearing in under the heading motion? Then it should be appearing under the heading hearing.
Hearing.
Very well. Learned advocates for the parties submit that. The pleadings are over. Stop. The matter is ready for hearing. Stop. Post it in the bundle of hearing matters in the next circuit. So many hearing matters are there in the list, so it has to go down. Some serial has to be maintained.
Party.
Well, based on the material record, I can trust the application.
If you are ready, I am okay with it.
So what has happened? In these islands, time to time, the scheme of regularization has been brought into force. Under which not should the encroachers who occupy government revenue land is entitled to get land subject to certain conditions to be fulfilled. An expert body was constituted, commonly known as High Court Committee. High Court Committee under that scheme. Insofar as the petitioner's case is concerned, this was accordingly considered by the High Court Committee, recommended by the Deputy Commissioner. Now, the steps which the authority is supposed to take is to issue a formal license in terms of local regulation. That they are not doing. I've been approaching the authority. They keep on passing an identical order saying, Lordship, that my case is not entitled for regularization. It's not a case of regularization. Regularization has long been done. I saw that order. And that order was passed pursuant to an order of this court. They have to simply, it's a corollary act. Once the recommendation is approved, once an order is passed, the same authority who passes an order, that Deputy Commissioner, has to issue a license. So, kindly see the order in which the Deputy Commissioner passed, which are challenged in the present application. It starts at page 47. They have, rather than some misinterpreting the entire thing, they said that regularization is not done. There's no scheme invoked in this island. That's not my case all about.
Show me the order of regularization first.
It starts at page. Yes. Next, wrong loss the first order of the High Court at page 27.
Yes.
Page 27.
Yes, yes.
It's order dated 20th July 1998. The STM under the learned advocate appears on behalf of the respondent. This is a writ petition for necessary direction upon the concerned respondent to consider the respective days of the petition for allotment of the plot of land in favor of each one of them on the ground that each of the writ petitioners are in present occupation of government land
Respectively
since before 1970. It has been submitted that in view of the scheme for disposal of government land in revenue village unauthorized occupied on or before 31/12/1978 and for creation of tenancy in respect of the said land framed by a policy decision dated 17 August 1987. The writ petitioners are entitled to allotment of their respective lands in occupation. However, since such allotment will depend upon proof of their respective occupation of land by each of the writ petitioners and of the other conditions for such allotment, so the writ is disposed of with the direction upon the Deputy Commissioner, Andaman District, to treat this writ petition as the representation of the writ petitioners and to consider the same in accordance with the provisions of law in respect of each of the petitioners, independently by making a reason orders. Therefore, in the event the Deputy Commissioner District Andaman holds in favor of the petitioners and of the any or other, then he will have to make necessary recommendation for such allotment by appropriate authority concerned. This writ petition is accordingly disposed of. Such disposal by the Deputy Commissioner should be made preferably.
This is the time period that is mentioned. Very well then.
And then also what the authority have did, it's at page 30. Annexure P3.
Yes.
I will just take cross to the recommendation which was approved at page of the so far as the present writ petition is concerned. Page 33, more to see. 33 towards bottom, serial number 2. Nikhil Haldar. And I'll just say that I'll take cross to that portion. Just one second.
Here there is only one petitioner.
36, yes. Page 36, the kind of see. Page 36, Nikhil Haldar.
Yes.
Or see, I'm just placing this paragraph.
Right.
The report of the Tahsildar Maya Bandar and the supporting document furnished by the Tahsildar and the petitioner has been produced, which reveals that Agni Haldar, father of the petitioner, had encroached upon an area measuring 0.83 hectares of government land in survey number 40 at Kamlapur village in the year 1975. And the case was instituted in the court of Tahsildar and it was ordered to be ejected from the land. Today, Tahsildar's RC number 20 of the 75, today RC order dated 25/7/17. But the petitioners continue to be in possession of the above land till his death in 1984. His son, that is the petition number 2, inherited the enclosed land and is still active possession of this land. Under the scheme of regularization pre-1978 encroachment, I find
it is a fit case to be referred to the competent authority for regularization this land under the said scheme.
Right.
This order was, it's a comprehensive recommendation. What would see at page 39 now. Page 39, my name has been identified at page 39 at the second paragraph. To sum up, the recommendation for regularization 378 category shall be made to the administration for approval of competent authority for the following persons to the extent of land action against them. The petition seal number 1. But it has been issued by the Deputy Commissioner on 3rd February 1991. The only course left to the authority is just to issue a license. I'll show that regulation. They have this recommendation is adjournment. It has not been recalled by any of the authority. Because I've been making representations. 41 is my advocate's notice. 41 and 42, nothing was done. Then 43 representations.
1 minute. 1999 is page 39.
Hello.
And after that, 41.
41 is the advocate's notice.
It's in 2020. So your client remained quiet for so many years. Right.
Can you turn to page 43 also? Page 43.
Yes.
It's 2010 representation issuance of license. Page 43.
All right.
The petitioner's name will to find at serial number 1 at page 43.
Yes.
Nothing was done. Then 44, nothing was done. Then I approached this court at page 45.
Yes.
So the authority, this court simply relegated the authority to take a decision. Decision has to be in the light of the decision already taken by the Deputy Commissioner. Simply they have to issue a license. Page 47 came to be passed, which I challenged. So thanks to the order.
Yes.
They have given a new color to the entire issue. So I'll just show that.
Impugned portion.
I'll just take it. It's page 49. Last but one paragraph. Page 49, last but and whereas.
Yes.
And whereas the petitioner is not eligible under the above stipulation of the said scheme being joint recorded tenant by way of purchase of land measuring area 2.15 hectare at Pasantipur village under the Mahamandra Tahsil. And whereas Andaman Nicobar administration issued a guidelines dated letter number so dated 17/08/87 to regularize the unauthorized occupation upon government land committed since prior to 31/12/1978 by way of creation of tenancy. The scheme of regularization was taken up pursuant to above instructions. Accordingly, in the year 1988, public notice was issued in the newspaper inviting applications from general public. The last date for receiving the application was 31st March 1988. During the period, no any applications was submitted in petitioner or his deceased father in pursuance to the said public notice. Since his claim was not genuine, moreover, no any cogent documentary proof has been submitted by the petitioner showing that the High Power Committee ever recommended the case of the petitioner or his deceased father. However, on verification of the case file on subject matter enforcement on government land in respect of Kamlapur village initiated during 1987 PR/RC/170 of 1987 for regularization plan, it is clearly depicted that no case is recommended by the committee. Hence, it is clear that the High Power Committee never recommended the case of petitioner or his father, Kumar Halder. And whereas the same scheme is one-time scheme and it's not in vogue. In view of the
please tell me something about this high power committee. When was it constituted?
It's pursuant to the scheme being brought in during the 1987. It's a committee of an expert body.
Wasn't the deputy commissioner who recommended your case
Yes.
at page 39 aware of this high power?
Yes, everything was taken care of. So that also. Simply sitting also the deputy commissioner, one line recommendation was not made. Based on the records, he made the recommendation. So again that at the cost of it. He considered every material on record. It's not that simply he recommended the case. I'll just show that. Just once. When it comes to page 31, second paragraph.
Yes.
Two number valuation 20. Petitioners also stated that during the year 1973, the Tahsildar Rangat issued a notice upon the father of the petition number 2, Agni Kumar Baldar, in connection with revenue case instituted against him as on 14/8/1975. The Tahsildar Rangat issued an order of stay of execution of the judgment order dated 8/8/1975 against the Agni Baldar, father of the petition number 2. That on 12/12/1990, the Circular Mayavati issued a notice upon Sri Nikhil Halda, the petition number 2. That on 2/11/1997, the Patwari of Govindapur submitted report before the revenue inspector informing that as per the encroachment register of Govindapur village, the land bearing survey number so and so situated at Govindapur village has been encroached by Dinabandhu Roy, petition number 2 since 1958. The
Petition number 3.
Yes, I'm coming there. I'm coming. The petitioner further stated that the Assistant Commissioner Mayavanda.
Where is Haldar's? The petitioner
Yes,
number
yes,
2's issue.
In the same paragraph, Marshal. It's in respect of other eligible encroachers. It's relating to other eligible encroachers.
No, in plural it is mentioned petitioners.
We come to page 36. Everything will be clear. Page 36 in respect of Nidhi Lalda. Page 36. Tahsildar, Deputy Commissioner, all the hyper committee members, Marshal. The report of the Tahsildar Mayavandar and the supporting documents furnished by the Tahsildar and the petitioner has been produced, which reveals that late Agni Haldar, father of the petitioner, had encroached upon an area of.
No, this you read out.
Yes, no.
So this I have
was taken
seen.
care of by the Deputy Commissioner being one of the member of Hyper Committee, and final conclusion arrived at by the Deputy Commissioner being the one of the member of Hyper Committee.
Now you come to page 50.
50.
50. The last line of the first paragraph. No case is recommended by the committee. It is clear that HPC never recommended. How from?
This is the principal thing. They have not considered the order of the Deputy Commissioner. The order which I have relied in the first round of litigation was not taken care of. The basis.
In the entire impugned order, is there anything mentioned about that 99 order of the Deputy Commissioner?
For page 47.
Yes.
Third paragraph. Page 47, the first page of the impugned order.
Yes.
And there is the claim of the petitioner as per the representation dated 28/10/20 is that Nikhil Haldar enforced the government revenue land bearing survey number.
Yes, the Deputy Commissioner considered the matter accordingly.
Nikhil Haldar
So till date the case has not been considered.
Declaration second. Thereafter,
For
he other
education
files
for-
CO number so and so before the Honorable High Court circuit bench at Bhopal. The Honorable High Court disposed of the matter with the direction to the Deputy Commissioner to consider the matter accordingly. Deputy Commissioner passed order on 3rd February 1999. Then he and others have submitted representation to the Deputy Commissioner on various days, but till date their case has not been considered. He further requested for issuance of licenses in respect of the said landed property on the basis of the Honorable High Court order and on the basis of the order dated 3rd February 1999 by the Deputy Commissioner.
So 3rd February order was there before the Deputy Commissioner.
But this was the finding arrived at by the Deputy Commissioner is not based on the.
Very well. Now tell me in the opposition what is their stand?
They simply say that scheme is the one-time scheme, no more exists, so his case cannot be recommended. This was not the claim all about.
Very well, I get it. Now, yes, respondent, what is your stand? Just tell me one thing, after the order was passed by the Deputy Commissioner in 1999, 3rd of February, is there any scope to reopen the issue? Or is it that after recommendation is made, the license is to be issued?
Just to consider, it was not there is no mandatory order for.
A recommendation is there. Recommendation, page 39.
Whether actually they were under possession or not. And as per the scheme, they were not landless person because the scheme was meant for the people who have got no land over in Andaman and Nicobar Islands. The scheme was mainly for landless people, and they were.
Is it your case that the petitioner has land somewhere else also?
They have been allotted with the land, and the document that I have annexed with my
Opposition. Please show.
Kindly come to my name. This are these collectively. They're not landless people. They have got their own landed property.
R3, which page? Which page?
Page 20.
Show me that the petitioner has other land.
Yes, page 20.
Page 23, late Agni Haldar.
Nikhil Haldar, son of
Nikhil.
Agni Haldar.
Yes.
Mutation allowed in favor of such and such. Nikhil Haldar is there now.
Page 23. 1 minute. Page 23 at the top, I see Dulal Haldar, son of late Agni Haldar. Then comes Nirmal and then comes Nikhil. Right.
Yes.
Now they are jointly holding this plot of land or what?
Right.
They are in joint.
Actually, Agni.
Yes. So on the death of Agni, the sons inherited the property. Is it because of this inheritance that you say that he will not be entitled to for the land?
What the landed properties were.
This is the property at page 23 that you are referring to.
Yes, 23, 24.
24.
81 by 1, 81 by 2, 92, 93 by 1, 93 by 2. These are all certain numbers.
93 by 1. Nikhil Haldar is
93 by 2 also. Nikhil Haldar is there.
all right. 92, 93 by 1, 93 by 92 is there. 81 by
1. And the Lordship may kindly come to page 33. Lord, in similar matter, this Honorable Court has decided this case now. This is the case where their predecessor were not considered by the High Power Committee. But they came for this Honorable Court after lapse of 30 years, claiming their realization of that encroachment, which their predecessor was not even got regularization. Their High Court Committee has not recommended their case. It is the same case. The similar type of case.
Where is the creation of this high power committee? Let me see.
My lords, next. Page 28.
28. 28 is illegible, cannot be read at all. See, page 30, whatever I can read,
Yes.
Shri Agni Kumar Haldar, he is no more. He died leaving his wife and sons. As per the field survey, it is found that such and such committed encroachment. She is not having any site anywhere in these islands. What does this mean?
But this survey number 14 was considered was regularized in favor of Radha Lakshmi Halla, wife of late Agni Kumar Halla.
Right.
That was regularized in the name of his wife. But he is claiming in his name. Now,
His wife means
his mother.
petitioner's mother. Right.
Yes.
He's claiming in his name.
No, his mother already got it.
That is separate.
Separate. Now he is asking for himself.
Yes.
As per the recommendation, as per the order passed by the Deputy Commissioner.
Right.
But my lord, in this matter, High Court Committee has not considered any. Only one encroachments, as per the list furnished by the High Court Committee, there are 5 encroachment cases that come into village. Out of this, only one is pertaining to prior 78. It's Agni Kumar Halna. So he was not alive at the time, so that it was regularized in favor of his wife. There, but now he is claiming some other encroachment to be considered in his name. Nikhil. then already he is having their landed properties.
See, Agni and then Radha, the husband wife, the mother and father of the petitioner. Father claimed, father did not have anything. On the death of the father, mother got it.
Yes. It was regularized.
It
Since
was-
he was not having the landed property, it was regularized. Now Nikhil Haldar is claiming some land which has been encroached by him subsequently.
No, but then record says that it is only from Agni that he is claiming. He is not claiming anything from Radha. From his mother, he is not claiming anything.
That's what, he was already considered for survey number 14. Now-
Mother was considered, not Nikhil. Radha was considered. Survey 14.
Because after the demise of Agni Kumar Haldar, his wife
Inherited.
inherited the property.
Now, Nikhil wants it from Agni. Radha is a separate number possibly because 90, 91, 92 that you showed me, they are all separate.
From Agni Kumar Haldar, they have got their landed property, which I have shown at page.
Yes, 90, 91 by 1.
Yes. All these are separate properties of Agni Kumar Haldar, which they have inherited. So they are not landless persons, my lord. They have already got this from Agni Kumar Haldar, which I have annexed, 23, 24. and
Serial number
25.
14, page 39 of the writ petition. See, in respect of Nikhil, it is survey number 14 that has been recommended. And now survey number 14, you show it has been regularized in favor of Radha. That means his mother.
Yes.
And then where from is 81 by 1, 81 by 2 come in? If 14 has already been regularized?
It has been allotted to Agni Kumar Haldar.
Please come to page 39 of the writ petition. Are you at page 39?
Aye.
See, Nikhil is survey number 14.
Aye.
Isn't it?
Yes.
Now, the document you showed me at page 30 of your opposition. This is in favor of Radha. Agni had it. After death of Agni, Radha is getting. All right.
Yes.
If this be so, then page number 23, 81 by 1, survey number 81 by 2, survey number, where from are these plots coming?
They're different.
How many can be granted? Recommendation was already in respect of 14. In 1999, was Radha alive? Because Nikhil can lay claim only to survey number 14, which was recommended.
Yes.
Now, survey number 14 has been recorded to be encroached by Radha or her husband, deceased husband, 97. Who is holding survey number 14 right now? In whose favor is it recorded?
Silent on this.
In whose way?
Because the recommendation that you are showing is of survey number 14.
Absolutely.
You can claim only survey number 14
Absolutely.
and you are not claiming anything else.
Certainly not. I'm concerned with the recommendations noted by the application in respect to survey 14. AA 0.83. It's come up on this.
But then survey 14 was originally occupied by late husband of this lady Radha, Agni.
This It's under their occupation.
So there.
If
don't you see-
assuming it is in their occupation, why will a license not be issued? This is what his claim is. And if 14 is there, then I don't know how come the other pages also come into play. Take instructions and come back.
Whether voting was in the name of, still in the name of their mother or.
Page 39 is dated 1999. Page 30 of the opposition which you rely upon is dated 1997. So 14 all along was occupied. Your officers are found to be occupied by Agni, then to Radha, and then on their death their sons and whoever is there. If these people lay claim to 14, then how come this 81 and everything comes in? It is for your officers to answer. 92, 93 by 1, 93 by 2. Mutation allowed in favor of Dulal Haldar and 2 others.
But may I say one thing?
Yes,
Because
please.
if you know, do not contain these things, let the authority revisit the entire issue. In the line of the recommendation. If at all license, if I take what the other side said to be a correct position, then the license should have been in the name of all the persons. Just for the sake of argument.
Tell me one thing. You lay claim to 14.
Yes.
How come this 81 by 1, 81 by 2, all these things come in your name?
Independent property which has nothing to do with the subject land. And even the scheme, there's no legal embargo. I'll show the scheme, very scheme. It nowhere prescribes that if I hold the property by way of inheritance, I cannot get an regularization. Rather, the schemes provide that provision. One can get, the limitations are provided. If it's
Show me those.
so that scheme, I have not brought it ready. Come tomorrow, these matters, I will bring the scheme.
Very
It's
well.
not part of the data, I will bring the scheme.
Not,
That's not the object of the scheme, Lord.
My opposition.
yes, please show.
Madam, page 19.
Yes.
Page 19, clause 10, subclause 3. Whether he had never acquired by purchase, inheritance, exchange, otherwise any land in the UT of Indian Islands, or whether he had acquired land by purchase, but the interest in his holding was extinguished.
But can you see the very
But
scheme?
not for this reason. Their case was not recommended since they were having their individual landed property.
Where is the bar recorded in
Yes,
this case?
no right provides.
The tehsildar then shall proceed to record on the statement of each person claiming relief under the scheme, carefully indicating these are the clauses that he has to.
No. Number one, whether he's a citizen of India or not. Yes or no?
Yes.
It has to be mentioned.
Never allotted land for agriculture or for construction of dwelling house by.
Right. Where is this bar that if there is any land allotted to him for construction, he'll not be entitled to the regularization? Where is that mentioned?
He says.
No, that is not the answer.
It's an open-ended scheme, it can't be one time, no time prescribed, it's an open-ended scheme, I would say.
No, open-ended is something else. Open-ended means out of date. But then whether there is any
No,
bar.
there's no restriction, Lord, should not reach between the line of the scheme. Nowhere it prescribes that the person who's having another landed property is not entitled to get the regularization. There's no line, even a single line. Rather than also the Tahsildar was given certain duties to make an inquiry on these aspects, submit it, while giving regularization, we consider this. Nowhere not shown the scheme, 87 scheme. The authority of their own, they're saying that, without any basis. So I'll make an submission, I would say, Lord.
Any judicial pronouncements on this?
There was no recommendation. There was no recommendation.
The difference, that is very important, the recommendation portion. Was this case page 34, Bimal Mondal? Was recommendation
No.
there?
No. No.
There is that it was their predecessor was recommended. by the High
Rejected by
Court.
the recommendation.
No, but in this case, the petitioner himself has been recommended. So this is different. You go through it, come back day after tomorrow.
The limitation is to be seen. because-
Very well. When do you propose to come back? When do you propose to come back? Next week? Yes, so it will take time.
Next Monday.
All right. Heard submissions made on behalf of both the parties. Stop paragraph. To allow the learned advocate representing the respondents to come ready with further instruction. List the same on 9th.
17, 1 and same. One question of 1, 14 and 17.
14 and 17, same order.
Same.
Very well, same order. 17 also recommendation there?
Same.
All right.
Same.
15,
Item number 15, WPS 360-2024.
They have given me the copy of proposition on 14th of November. Just I take the privilege to give a reply within 1 day. That's not needed. Next week, any day. Any day.
learned advocate representing the petitioner seeks time to file reply to the opposition by the respondents. Stop. Let opposition be prepared and circulated by 16th. List on, not 16th. 16th is the last day. Will that be okay?
There is an interim order operating than that.
Then 9th.
9.
9th.
Right.
List on 11th. 11th,
Yes.
15 and 16.
15 and 16 same.
Same.
My lord, 16, my lord. My lord, 16, my lord.
WPS 450 of
My lord, am I audible, my lord?
Let me see the file once.
My lord, item number 16, my lord.
Not prepared?
My lord, am I audible, my lord?
Learned advocate representing the respondents. Time to file the affidavit in opposition is extended till how long? That takes us to the end of this circuit. Till 20th of December. With a copy to the learned advocate representing the writ petitioner. Stop. List in the next circuit.
IDs 475 of 2024.
I hate to I have
Like,
responded for
like
one.
it was on 11, 2024, the information has been given on this by divided by 9. Then for 11, this can be taken.
I'm giving my.
I'm hearing for the respondent number 3.
I'm for one.
Answering respondent is 1 and 2.
Private respondent as well. Respondent number 4. So I have submitted my affidavit of the comments.
Very well. Only the reply from you.
Since the court, the respondent of 4 has filed today must come to the next activity. There's an interim protection that needs to be extended.
That needs to be extended. Let me see. What is the protection that you are enjoying?
They will not take course steps. My lord, only thing is, my lord, this party has also filed an appeal before the revenue authority.
All right.
Against the same order. So, my lord, this can be disposed of by the.
Directing the authority to take its action in the matter.
Case for interim protection also.
His submission was advanced, it was considered by the court, interim protection has been granted. Now the matter should be taken a final one. This was advanced.
Very well.
No, but my lord, the point is that.
Let me use my reply. You use your position. Let me use my reply.
And the affidavit in opposition by the respondent number 4 has been served upon the learned advocate for the petitioner in court today. Stop. Paragraph, the petitioner intends to file a reply to the same. Stop. Let the reply be prepared and circulated by 20th of December. Stop. List the matter in the next circuit. Stop. The interim order that is subsisting in the matter is extended till
November 8, 2024.
yes, till the last day of January 2025. There is no requirement of extension.
Fine.
List in the next circuit.
WPA 484/24. And for the decision.
This matter, my lord, can be disposed of, my lord, challenge to a so called.
And for the invitation. November 11th order may be seen. They raised the maintainability question. This honorable court discarded that, corrected for filing affidavit. They choose not to file the affidavit. Order November 11th order. And two important documents, I failed to file. I prayed before the honorable court filing supplementary affidavit. That also I filed. If
You
they don't
filed.
want to file any reply to my supplementary affidavit, let the matter be taken up tomorrow as item number 1. No objection for it.
What is your issue?
Issue matter, Sogas notice was given.
What is the show? Where is it?
Clubbing everything in one Sogas.
Everything means
3 incidents in one Sogas. Page 22.
three grievances received by the grievance redressal committee.
Yes.
You are Dr. Achinamai from such and such, copies of emails. I see
Totally
three grievances
different,
against you from the, you have appeared for the inquiry. As per request, the copies of 3 grievances are enclosed.
And kindly see last 2 lines, only 5 days time for reply.
There's a regulation which requires us to give complete it within a few.
I'm ready to argue the matter, provided if you don't want to file the reply to my supplementary affidavit, I am ready to argue.
What is there in the supplementary?
Some important documents, I failed to file at the time of filing the original request.
Yes, what is
That
it?
is, my lord.
Did you get the copy of the complaints, 3 complaints?
Yes.
The grievances,
Yes.
there are 3.
Yes.
You got copy of all 3.
Yes.
Did you submit your response?
No. I
No.
directly challenge this before this under. They raised maintainability issue. First order may be seen by this honorable court directed them to file the affidavit. They choose not to file the affidavit. It was also recorded November 11th order.
No, I understand the incident under the IN were rejected outright.
I am ready for the hearing, provided.
I understand,
Yes.
but then what are the documents that you are relying upon in the supplementary?
Yes, kindly come to my supplementary.
This
Page 7.
page 7,
This is dated 20th July 2024.
right?
Returned to the director
Yes.
regarding the person who lodged complaint against me. That is serial number 1, page 22, serial number 1. From Dr. Prabhu Gowda. This is of 20th July 2024. Till date, no action was taken. Prabhu Gowda lodged a complaint, immediately they issued a notice to me.
1 minute. The impugned communication is at page 22, which is under challenge.
Hello.
Copy from Prabhu Gowda,
Yes.
senior resident.
Yes,
And you say page 7 has not been considered.
consider.
Page 7, what is page 7?
Page 7, confidential. I am the head of the pathology department. I am professor in pathology department.
All right,
The Prabhu Gowda is working under me.
all right.
He is regularly irregular, he is forging the document. I requested them not to extend his contact.
All right.
Contract. Page 7. Yes.
7 is something, the reason for delay.
Department of Pathology.
No, it's not page 7. It's page 4. 10th of September 24.
No, Mira, the next one, Mira, by mistake, maybe.
Page 5.
Page 5. Page
20th of July 20.
Page 5.
20th of July.
Page 5.
Yeah, this is the reason I couldn't connect both the papers. Yes.
Page 5, Mira, I am sorry.
Yes, yes.
20th July.
Yes.
I wrote this to the director against Dr. Prabhu Gowda
Yes, yes.
for negligent attitude for parents, patients care. Number 2, forgery signature for colleague SR in pathology department of daily attendant register.
And negligent attitude in teaching.
Teaching and teaching evaluation.
Hmm.
No action was taken. When Prabhu Gowda lodged a complaint, they issued this notice to me. This is first issue. Second issue, my lord, kindly come to page 22 once again.
22.
Last one, my lord. 3 copies of emails from external examiner, April 24, university exam pathology.
Hmm.
From Pondicherry University, some examiners came here to conduct examination. We have to pay some fees to them. It was paid even after this Sobas was issued. Kindly come to.
Where are the emails?
I'm coming. Email matter page 11 of the application. Page 11, my lord, we got
We have not received the remuneration yet and would like to know if there is any delay to the late submission. On 7th May 2024.
Yes.
When was the remuneration paid?
1 minute. This was on 7th May.
Hmm.
Kindly see the reply.
Hmm.
9th May. I apologize on behalf of the institution for unpleasant experience. The amount was paid long back. Kindly come to page 18. They want to punish me, my lord. That is the reason this focus was issued. Page 18, Lordship will find serial number 2, 8424. Pondicherry University exam paid. Fee was paid. Page 18.
Yeah, I have seen it.
Yes. Thereafter, page 19, the speed post receipt was dispatched. It was within the knowledge of the principal. Even then, the director issued this committee was constituted for inquiry against me. All 3 different cause of action, it can't be clubbed in one. This is my first submission. The issue is already settled. Already payment they received. The head of the department writing on 9th, page 11. I dispatched it on 8th. Without verifying the document, they are writing on 8th.
Yes.
This is number 2. Number 3,
Jagdish Kamal Chandar.
Associate Professor Medicine.
Yes.
Actually, my lord, I am not prepared to answer this today. Because I thought it's a supplementary affidavit, they will file the reply. If they don't want to file, tomorrow I will come with preparation.
All right. Tell me. 3. The email communication regarding non-payment. Check up. He can always come up, but then if there is no reason to issue the show cause, if you issue show cause on documents which are already with your record, Then why did trouble this person?
They want to dismiss me from the service. See several complaints, madam. You can just because a person against whom he has also complained is a complainant in this case, that's only interlinked. They are completely different things. If then he should file a.
Did you take any steps against this Prabhu Gowda?
How?
That is separate, but did you? He is alleging discrimination. He is alleging bias, malafide attitude, action on your part.
Cannot we then file opposition and to both the supplementary affidavit and the.
So now they cannot say this, madam.
No, why can't we?
Yes.
Your submission is recorded that you have chosen not to.
Posing this question, my lord.
These questions will come. The petitioner is not going to leave. Right.
These issues are separate cause of action, my lord, doesn't work. This is like, whereas in a legal writ petition, my lord, this is like, this is not a, my lord, mediation proceeding, my lord, so far as the petitioner is concerned. He cannot bring unrelated grievances, my lord. Assuming that we have not.
You relate three complaints in one, and when he raises an issue.
All these things he can raise before the authority, my lord, that.
Listen, show cause is not a punishment, nothing of the sort. So at the show cause stage, the court usually prefers not to interfere. But then if it is apparent that there is some bias on your part to harass this person.
Because this has fallen from your lordship, so therefore I am paying for an opportunity to file.
Yes, from the day one, madam, when 1120 submitting, you will not find.
No, because this query had never fallen from the bench, what lordship is now saying, so therefore, this question will require affidavits.
Now I am objecting for any affidavit.
How can there be presumption?
Yes, you have submitted 11th November order may be seen. You yourself submitted before the court. You will not file any affidavit.
But now you have filed the supplementary affidavit.
You can file reply to supplementary affidavit. No problem.
No, why should he come in the way of the truth surfacing, my lord? If there is a what is the difficulty in filing an affidavit?
Truth is always truth.
1 minute. As regards the second issue from Dr. Jagdish Kamal Chander, what is the complaint? Do you have any complaint against this person also? Because what I was thinking is, the petitioner has lodged complaint against this Prabhu Gowda first, and in respect of third, he has at least annexed something to show that the payment was made prior to you issuing the show cause notice, and those documents are already there in the writ petition, right? Now, why don't you consider all these things?
Yes, ma'am.
They will cost. They will planning to business me.
No, I
contract basis. I am in contract basis.
No, why not we consider everything? No, writ petition and supplementary affidavit both can be considered.
No.
And why not a speaking order will be passed? After
Page
that,
8. Answer is at page 8.
so how can the petitioner is trying to come and prevent the show cause notice proceeding from carrying forward?
Page 8 is,
Listen,
listen, if you say that the show cause 3 cannot be clubbed, they will issue 3 show causes to you. What will you do?
I will give separate reply.
You want, I'll direct you to give separate replies to these?
No, kindly appreciate it. This may be decided on merits. Page 10 may be seen.
What, at the show cause stage, what can be decided on merits?
But decision without jurisdiction, I can approach the progress.
Where, what is the jurisdiction issue over here?
No, I'm saying how Sokas notice can be.
No. Over here, you are not raised the issue of jurisdiction.
No, but I can.
You say 3 complaints from 3 different persons cannot be tagged into one.
This is first issue.
Second is 2 of the things you've shown me, that one in respect of Prabhu Gowda, you had made a complaint not taken into consideration. As regards the payment you have made, they have not. These 2 I understand.
The answer is page 10.
Page 10.
It's a vague complaint, no date, no place, nothing.
Very well. It's a complaint is vague. So
I can always come to the court. Complaint is
I can direct you, grant you leave to file 3 replies to the 3 allegations, the grievances that have been leveled against you.
Yes, they want to
What to be decided?
dismiss me from this.
At the show cause stage.
Yes, they do it. Did it, my lord, last.
Then the writ petition is available. The scope of writ is already there for you.
Only one thing I want to show. Page 10, my lord.
Page 10, yes.
Reverse letter of Dr. U. Jagdish Chandra. Kindly see this one. No date, nothing is there. When I misbehaved with him. Nothing is there.
Page, one minute, page 9 and 10 is your appointment letter. All, oh, supplementary affidavit. Page 10, grievance letter, 17th of August, 24. Umesh Kamal Chandar.
Yes.
Professor.
No date, place of occurrence is not there. How I can give reply to this?
So this cannot be challenged, my lord. I'll place a judgment challenge in that case, my lord. Permit me, my lord.
Vague complaint.
I mean, vague complaint is not a ground to challenge the show cause notice. My lord, permit me, I'll place the judgment.
And my lord, page 11. Similarly, first day Sokas was issued, second day he was dismissed from service.
That is a completely different.
No, completely different. I am also accepting. We approached this honorable court, they withdrawn their dismissal order.
There was no time given on it. Within
Yes.
a day, you've got 5 days.
3 months, you are giving me 5 days time.
All right, they'll give you some more time.
They want to dismiss me from.
One of the guidelines says within 21 days it has to be completed. That is why 5 days have been given.
And moreover, your documents are already there with you. Why don't you reply? 11th of September 24. The complaint,
Yes.
the show cause, 11th of September. Page 22, right? 5 days long over.
Yes. I immediately approach this honorable court.
I get it, but then if time is given to you to file the reply, it can be done.
The second one, third one is already over. The making payment is already over, closed chapter. They cannot reopen.
Let them consider it.
They will definitely cause damage to me.
No, my lord, this cannot be, man. This
Yes.
cannot presumption, man.
That is-
This
that
kind
is
of
the reason.
No, my lord. Then
I have enclosed one document showing that this is
then you can challenge it the next day and get a stay if there is any malafide.
It's 11, I have
malafide
shown.
action.
First
There
day,
cannot be
first day
presumption.
notice, second day dismissal order.
That is a completely different situation, my lord. That is
Let them find the reply against this my supplementary matter may be decided.
This is not fair, my lord.
Why in fact you
my lord,
submit before this court?
His show cause notice is a problem, my
Thing
lord.
is, at the show cause stage,
My lord.
at least in respect of the show cause, the court is not inclined to interfere.
Correct, your lordship is absolutely correct, but there are
Relying on page 22,
grounds, my lord. So cause can be challenged.
none of the grounds which you say is applicable here.
Applicable. Without jurisdiction, I am not claiming.
Yes,
Number issued after decision.
yes.
The decision was taken, email, matter is already over.
Let them say.
Apparent
Please wait.
Doesn't say anything.
Please wait.
from the record.
Please come.
Show cause notice doesn't contain any allegations.
Please come.
At page 20.
The petitioner is aggrieved by the show cause issued to him on 11th September 2024. Step. The show cause refers to 3 separate complaints made by 3 separate persons. Step. With regard to the first grievance. No, the first grievance relates to a complaint from one Dr. Prabhu Gowda, senior resident within bracket pathology.
Working under me.
Stop. The petitioner submits that the aforesaid Dr. Prabhu Gowda is working under the petitioner. Stop. The petitioner lodged complaint against the said Prabhu Gowda before the director ANIIMS in by way of a confidential communication on 10th May 2024. Stop.
No, 20th July 24.
Page number.
Page 5, supplementary.
In the writ petition also you annexed something? Page 10, page 14. No, page 10. Page 5. All right. 20th of July 2024. Stop. The authority, instead of consideration of the communication made by the petitioner, issued the show cause against him, relying upon a complaint from the said doctor. Stop. Paragraph. The impugned show cause also mentions about a complaint from one Dr. Jagdish Kamal Chander. Page 22, please check, you'll get the spellings. Associate Professor within bracket Forensic Medicine. Stop. The petitioner submits that the alleged complaint, not alleged, the complaint of the said Dr. Jagdish Kumar Chander is absolutely vague. Stop. There is neither any date nor the details of the incident mentioned in the complaint, and no action could have been taken relying on the same. Paragraph. The third grievance is with regard to email communication from the external examiners of pathology within bracket April 2024 university exams. Stop. According to the petitioner, the payment, not payment, the remuneration of the examiners were paid prior to issuance of the show cause notice. Stop. The authority, instead of verifying the documents, had issued the show cause notice only with the sole intention of dismissing the petitioner from service, who is a contractual employee. Paragraph. With the leave of the court, the petitioner has filed a supplementary affidavit in support of the documents relied upon by him in response to the show cause which has been issued. Stop. Do you intend,
So far, not submitted any reply.
in support of the submissions that you are making today, do you intend to use any other document in your support in response to the show cause? You cannot say.
The opportunity can be given, but let them file whatever you want. Okay.
The court, comma, at the stage of a show cause, comma, usually do not entertain petitions because show cause is never a penalty that is given to an employee. The show cause is merely an opportunity to the employee to produce documents in his slash her support to defend his stand against the allegations raised against him. Stop. Next. In the instant case, it appears that the petitioner has documents in support of his stand. Stop. The petitioner was aggrieved as three different grievances from three different persons were clubbed together and only 5 days time period granted for submitting the show cause. Stop. By now, the petitioner has got enough time to submit the reply to the authority. Stop. Next. Accordingly, the petitioner is granted leave to produce all documents before the authority in support of his stand. At the earliest, but positively by 9th of December 2024. Stop. You've got more than 2 months time, but the documents are there with you. Then why delay?
10 days time, but 3 days nothing there. 4 days.
Till 12th of December. Stop. The authority shall give a reasonable opportunity of hearing to the petitioner. And thereafter pass a reasoned order. Within 4 weeks from the date of submission of the 4 weeks from the date of hearing. Stop. Paragraph. It will be open for the petitioner to make all submission and rely upon all documents in his support. Stop. Next. In the event any adverse order is proposed to be passed, comma, the same shall not be given effect to for a period of 1 week from the date of communication of the order to the petitioner. Yes. For a fortnight.
This 20 days time.
Why not, in my humble submission, it's premature, my lord.
At this stage, so many days cannot be given. See, if the circuit bench over here is not there, at least the principal bench will be there. So that way it cannot be done. Fortnight, for a fortnight.
The complaint lodged by me against the particular doctor.
No, my lord, I have received instructions that some of those already inquiry has been done, so let it be open, we record it in the order.
I'll record your submission that inquiry has started.
So, and for one person, somebody has found to be innocent, let it be, my lord, that we got the order.
At the time of consideration of the
Status, my lord, status.
at the time of consideration of the at the time of hearing the petitioner with regard to the complaint made in respect of Dr. Prabhu Gowda, comma, the authority shall take steps to consider the communication made by the petitioner on 20th of July 2024.
But I have been told that he has been found innocent.
What serious idea has been documented?
Communicate it to him.
Fine.
That will suffice.
Document, my lord, I got
Very well. The writ petition stands is posted. So the list is over.